Hi, this is attorney Michael Pariente at the Pariente Law Firm PC, John G. Watkins of counsel, here in my conference room at the Howard Hughes Center. I'm a criminal defense lawyer here in Las Vegas, and I've been practicing law for the past 18 years. Today I'd like to talk to you about the latest U.S. Supreme Court case of Utah versus Strieff. Now, typically what happens is, let's say that you're driving and the police pull you over and they have no reason to pull you over. In other words, you haven't violated any traffic law. So there's no reasonable suspicion of any wrongdoing and there's no probable cause. If the police pull you over for no reason at all and they search your car, then anything that they find is excludable under a doctrine called the fruit of the poisonous tree doctrine, which means that it's not admissible in trial against you. So if the police find drugs in your car, then they can't use that against you, even if you admit that they're your drugs, because the stop was illegal. It violated the Fourth Amendment. Now, the case of Utah versus Strieff is a very peculiar decision. In my opinion, it's a terrible decision. Here's what happened in the Strieff case. A gentleman in Utah was walking outside of a house where there was suspected drug dealing going on. A police officer walked up to Mr. Strieff and said, "Hey, I want to talk to you." Mr. Strieff didn't want to talk to him, but the cop would not let him leave. Even the state of Utah, in arguing before the U.S. Supreme Court, conceded that it was an illegal stop. In other words, the officer didn't have probable cause or any reason to detain Mr. Strieff. Now, during that time, while he was detaining him, he called down to the headquarters and they ran a background check and determined that Mr. Strieff had a warrant out for his arrest. He was taken and booked, and during that search incident to arrest, when he was booked into the local jail, they found contraband, which they used to prosecute him with. So he was charged with violating a felony possession of controlled substance law in Utah. Now, the lawyer that he had argued, rightfully, that the drugs should be suppressed as a fruit of the poisonous tree under the fruit of the poisonous tree doctrine, because there was no basis to stop Mr. Strieff, and therefore anything that was found after the illegal stop should be excluded. Well, Utah took that up to the U.S. Supreme Court, and the U.S. Supreme Court said, well, in this case, because there was a warrant, that's an intervening factor, and because there's a warrant, then it excuses the unconstitutional action on the part of the police officer who stopped him for no reason at all. And they said that the drugs were hence admissible. It's a terrible decision because so many people out there have warrants for their arrests for minor things like just traffic tickets or parking tickets. And it's scary to think that an officer can walk up to you, detain you illegally, and then under the guise of checking to see if you have a warrant, decide that he's going to arrest you if in fact it turns out that you do have a warrant, and everything on your person is now the subject of an admissible activity against you. So if you're in a situation where you have an active warrant, make sure you retain an attorney, either me or any attorney, to quash those warrants, because you don't want to be in this situation. If you have any questions, don't hesitate to give me a call or come sit down with me in person. I'm more than happy to talk to you about how I can help you.